All right, good afternoon again and welcome to the appellate court. I am Judge Cradle and I'm sitting today with Judge Alexander and Judge Levine. This is the matter of LPP mortgage versus Underwood Towers, AC 43575. This matter is being live streamed on the Judicial Branch's YouTube channel, and the recording of this argument will be posted on the branch's website. To the extent there's any protected information involved in this case, I would ask or remind counsel not to divulge any protected information during the course of their argument. To make sure that we can see and hear everyone, I would ask the parties to introduce themselves, beginning with the judges, followed by counsel for the appellant, and then a counsel for the appellee. I am Judge Cradle.
Good afternoon, Judge Alexander.
Good afternoon, I'm Judge Doug Levine.
Good afternoon, Wesley Horton.
Good afternoon, Your Honor. David Hoops for the appellant.
Okay. I'm going to ask that everyone, or remind everyone, to mute their microphones when they're not speaking, just so that we don't have any feedback. And please keep your camera on at all times during the argument. We will try to raise our hand if we have any questions, and if you do not notice us doing that, then we will jump right in and ask a question. Again, this is a courtroom proceeding, and please conduct yourselves as if you were present in the courtroom. Each side will be permitted 20 minutes of argument. The appellant may reserve a portion of that time for rebuttal. And please let me know before you proceed how much time you would like for rebuttal. Judge Alexander will be keeping track of time. She will let you know when you have 2 minutes, 1 minute, and when your time is up. Each of you have received instructions. If you have any questions, let me know before we begin. All right, any questions? All right, you counsel, you may begin.
May it please the court, my name is David Hoops. I represent the defendant, appellant, City of Hartford. I would like to reserve 5 minutes for rebuttal, please. The issue in this is whether the plaintiff has standing to foreclose a mortgage securing a note where it is undisputed that the plaintiff is not entitled to enforce the note under the UCC. This matters greatly to the City of Hartford because if the plaintiff can foreclose its mortgage, then liens securing millions of dollars of delinquent and unpaid pilots' payment in lieu of tax amounts will be extinguished. Trial court ruled that the plaintiff had standing under the Bedford case from 1996. And that case does indeed hold that one not need to be a person to enforce a note, at least under UCC section 3-309, which deals with lost notes, in order to have standing to foreclose a mortgage that secures a note. However, Bedford was overruled by clear implication by 2 later decisions of the Supreme Court, J.E. Robert Company, and especially Equity 1 versus Shivers, which I'll refer to as Shivers. 2 sentences from Shivers crystallize how these decisions cannot possibly be reconciled with each other. At page 126, the Shivers court stated, several general principles concerning mortgage foreclosure procedure also guide our analysis. Standing to enforce a promissory note is established by the provisions of the Uniform Commercial Code. Now, contrast this with the following statement by the Bedford court, which is really the operative statement, and it encapsulates its holding. The Bedford court stated at page 210, thus, whatever restrictions, sections 42A-3301 and 42A-3-3309 might put upon the enforcement of a personal liability based solely upon a lost note. They do not prohibit GHR, which was the plaintiff in that case, from pursuing an action of foreclosure to enforce the terms of a mortgage. But both statements cannot be true at the same time. It's a statement of Connecticut law, at least. Either you have to satisfy the UCC requirements or you don't. The post-Bedford decisions say you don't, and I think the reason is quite obvious. Foreclosure of a mortgage securing a note is obviously a means of enforcing the note. And that's why every decision that we could find in every other jurisdiction that's considered the issue agrees with the Shivers Court and disagrees with Bedford in holding that to have standing to foreclose a mortgage, you have to be, quote, a person entitled to enforce a note, quote, that's the term of art that's defined in UCC 3-301. And in my brief, for ease, I use an acronym, PETE or P, person entitled to enforce a note. The plaintiff says J.E. Roberts and Shivers, and numerous decisions I will point out of this court that follow J.E. Roberts and Shivers don't control because, as I understand their argument, they don't involve the exact same peak status issue that was involved in Bedford. And it's the same issue that's involved in this case, which is the peak status issue here, as in Bedford, has to do with the fact that the plaintiff here never had the note. UCC-301 is clear that in order to enforce a note, you have to be a person entitled to enforce a note. And there's three situations that are laid out in the statute, and one of them is if the note's lost, you have to qualify as a P under 3309, and you can't be a P if you never had the note. It's like buying a car without getting the title signed over to you. If you buy a car and you have the title, you can apply for a lost, you can apply for a new title. If you never had the title, you don't really have anything. The argument seems to be by the plaintiff that you have to be a P to have standing in every case, or pretty much every case, except where the exact reason you're not a P happens to be the reason that the plaintiff here isn't a P, which is that they bought a note without buying a note. There's no logical basis for this kind of carve out from the general rule, and nothing in Shivers or any of the appellate court cases that have followed J.E. Robert and Shivers, or any of the sister court cases on this issue remotely suggests that there ought to be such a carve out. In fact, there's at least 3 appellate level sister court cases that involve the exact same peach status issue that we have here, which is not just any old non-Pete, it's a Pete, it's a non-Pete who's a non-Pete because they bought a note, or they thought they bought a note, they never actually got the note. So quite simply, you have to be a Pete that's standing to foreclose, not sometimes, always. Now, one might ask, why didn't the Shivers court mention that they were overruling Bedford? And the most obvious explanation is that it wasn't brought to the court's attention, or the court didn't realize that their holding, I'm talking specifically with reference to the Shivers court here, that it was contrary to Bedford. If they did realize that, or if it had been brought to their attention, you would certainly expect the court to say something like, oh, the plaintiff argues that under Bedford, UCC 3-301 and UCC-3301 aren't relevant, but we disagree that for this particular kind of peak problem, that doesn't matter. And here's why it matters sometimes, but not all the time. And they didn't say that. These cases make it very clear from the statements and just from the analysis, from the fact that in all of these decisions, Shivers, J.E. Robert, and the several appellate court decisions that I cite, specifically Ugrin, Lazard, and Bliss, that they all went to great great pains to analyze whether or not the plaintiff in that case was a Pete. And there was a variety of different Pete status issues. A lot of them involve the issue of an endorsement in blank, who can, whether you can, if you have an endorsement in blank, whether you can then specially endorse it. And there's a variety of different Pete issues. There's no suggestion in any of these cases that it matters what, the reason why you're not a Pete or the reason why your Pete status is put at issue. There's one particular point that I'd like to make in response to the plaintiff's argument, and this is actually touched on in the previous argument, where plaintiff's counsel stated that the issue in Bedford is whether the loss of in personam remedies extinguishes in rem remedies, and plaintiff's counsel characterizes, and I understand why plaintiff's counsel wants to characterize the holding in Bedford as in that way, whether or not the extinguishment or the absence of an in personam remedy extinguishes in rem remedies, but that's not the issue at all in Bedford. Bedford didn't talk about that, and counsel also mentioned the McKay case from a sister jurisdiction. Counsel said, well, McKay doesn't say anything about in personam remedies versus in rem remedies, and there's a pretty good reason for that, which that's completely irrelevant. It's an apples and oranges comparison. What the plaintiff respectfully is doing is improperly conflating the existence of in personam liability with entitlement to enforce a note. The two separate things, completely separate. And a good example, the plaintiff's counsel cites a number of examples by way of analogy, and again, it's a misplaced analogy for this proposition. One example is classic example of a bankruptcy discharge of an obligation on a note where there's a mortgage securing the note. Obviously, the mortgage rides through the bankruptcy. But there's a number of other examples. The cleanest example is actually the one that was involved, happens to be involved in the J.E. Roberts case, which is a non-recourse loan. A loan where the note says that you can't pursue the debtor in personam or personally. You can only look to your collateral. So that's an example where right from the get-go there is no in personam remedy available. And yet, when a bank makes, or when a lender makes a non-recourse loan, they're very careful to insist that they get a note, even though it's a non-recourse note. Why do they bother getting a non-recourse note? Because it's critical. A mortgage can't stand on its own. This really gets to why Bedford is so wrong. A mortgage cannot stand on its own. It has to secure a separate obligation. And if that obligation is evidenced by a note, in order to enforce the mortgage, you have to be able to enforce the note. And to enforce the note, you have to look to applicable law to see what's required to enforce a note. And that law is applied by the UCC. And if UCC section 3-301 and 3-309 didn't matter, and actually it's really only 3-301 that matters in general. If UCC didn't matter, there's no reason J.E. Roberts would have discussed it. There's no reason Shivers would have discussed it. There's no reason that this court would have gone to great lengths to discuss the UCC analysis in Ugrin, Lazard, and Bliss. In all of those cases, there was no question that the plaintiff owned the mortgage, if that's all that matters. The mortgage there were assignments of the mortgage. So why bother talking about, in all these various contexts, why the plaintiff is or is not a Pete? You have an assignment of a mortgage. That would be the end of the story. But what's wrong with Bedford fundamentally, and why it didn't stand the test of time, is that it really turns the relationship of a mortgage and a note right on its head. The mortgage follows the note, not vice versa. You have to have an obligation, and if the obligation is secured by a note, once again, you have to be able to enforce the note.
You have just over a minute and a half.
Okay, well, I would like to reserve the rest of my time for rebuttal, if I may, unless there's questions.
Very good. Thank you.
Thank you.
Attorney Horton.
Yes, thank you, Your Honors. I'd like to start off by telling the court what the test is for implicitly overruling a case, because the one case he cites, and it's the correct case, is Witchers versus Hatch, which is 252 Connecticut 174. And let me tell you what the test is on page 186. In that case, the Johnson case, which was an old case, said that an award of economic damages that is not accompanied by an award of non-economic damages is inadequate as a matter of law. That's what Johnson said from 1930. Then the Childs case came out in 1985, and it said such an award is not always inadequate as a matter of law. In short, the two cases were inconsistent. You couldn't do both. If you followed Johnson, you automatically violated Childs. In other words, implicitly overruled means that it's impossible as an appellate court for you to follow both cases. It can't be done. Here, you clearly can follow both cases, because J.E. Roberts, which had to do with whether a load servicer could be a Pete, and Shivers, which said whether you can prove a Pete by informal proof. Neither of them had to do with a lost note. That's the first thing. But most important is the issue was whether they were a Pete, not whether they had to be a Pete. The issue of whether they had to be a Pete was not in the case. So it's just the Supreme Court decided the issues that were before them. The issue was, can a loan servicer be a Pete? Shivers, can you prove a Pete by informal proof? That's all that was involved in those two cases. And what Attorney Hoops tries to do is come up with some language that sounds like it might have something to do with implicitly overruling the case. The only language he specifically cited today is from Shivers, and the precise sentence, I've got it in front of me, says, standing to enforce a promissory note is established by the provisions of the Uniform Commercial Code. Well, that's fine. We're not asking to enforce a promissory note. That's not what we're asking to do. And his idea that you've got to be able to enforce the note, it's enforcing the debt. And this is a case that the J.E. Robert case discusses, and in the Simulitis case that we've cited, that was a decision authored by Judge Levine, says that when you're talking about the note, those cases, the language about the note and the debt are basically, you're talking about the same thing, is to address the situation in which the ownership of the note and the ownership of the mortgage rest in different hands at the time the foreclosure action commenced. That's not an issue here. So his point about, he's basically conflating ownership of the note with ownership of the debt. And so I go back to the Witchers case. You can't say that the Bedford Realty case has been implicitly overruled. And in fact, just 6 months ago, this very court in the Castle case cited the Bedford case came up again. The problem was the plaintiff didn't prove they owned the debt. So, but they analyzed it under Bedford, and this is just 6 months ago. And furthermore, just last year, the Supreme Court wrote the Esagov case, which held that you couldn't, that 49-1 of the statutes, makes it very distinguished what your rights in equity and your rights in personam are. And in fact, this showed up recently in the Mangiafico case, in which the statute of limitations had run, so you couldn't sue on the note, and yet Mangiafico said you can still foreclose. I'd like to mention the Johnson case, because opponent brought it up, Mr. Hoops brought it up, and it's also the point is, well, of course, in bankruptcy law, because there's a bankruptcy statute on the subject, of course, you can still foreclose on the mortgage. Well, let me read you just a language from the Johnson. This is the United States Supreme Court case, and this was cited, by the way, in the Hallam's case, which was a per curiam decision by this court 2 years ago. It says, however, such a discharge extinguishes only the personal liability of the debtor, which was what Attorney Coops conceded. But read the next sentence. Codifying the rule of Long versus Bullard, which was an old United States Supreme Court case, the code provides the creditor's right to foreclose and the mortgage survives or passes through the bankruptcy. Codifying the common law rule. That was before there was a statute. That was the common law rule by the United States Supreme Court, making a difference between rights in personam and rights and the right to go in rem. So, and that also addresses the First Circuit case in Summers, which he says is distinguishable because it has to do with Rhode Island probate law. He's right about that, but guess how the reasoning goes? The reasoning goes, I'm reading now from Summers, and I'm reading at page 357 of the decision. A compelling analogy can be found in the realm of bankruptcy law. And guess what case is cited? Johnson versus Homestay. So those cases both, the idea that Attorney Hoops has that Bedford is a big outlier, and he goes further and says that not only has been implicitly overruled, he actually takes the next step on which you can't find much Connecticut law on the subject. Namely, even if they haven't implicitly overruled it, the decision is so bad that they certainly would overrule it if it came before them. And guess what his citation for that is? A Ninth Circuit case. That's it. No Connecticut case on that proposition. So my view is that you not only is this not something that's been implicitly overruled, but there's no reason why they would overrule the decision, because it follows cases such as the United States Supreme Court, and it follows from the Esagov decision, and it follows from a long line of Connecticut cases having to do, and I think the best reasoned decision on the subject is Justice Peters's decision that she came out with in the 1990s, and it's the one that's most directly on point. Excuse me, and the excuse me just a second, need some water. And that's the Jager case, and in which she makes it very clear that even though judgment had been entered and you couldn't anymore claim any more personal rights, in personam rights, nevertheless, whoops, we made a mistake and we left out some of the land on the mortgage. In equity, the judge, using equitable considerations, could add the land to the mortgage after all personam remedies were gone, in order to have a remedy in rem on the mortgage. And so the Jager case is perhaps the leading, in my opinion, is the leading case on this area. So what Bedford did is following a long line of Connecticut cases on the subject, and this long line of cases that Attorney Hoops cites from out of state, you look in vain in those decisions to see them talk about the difference between in rem and in personam remedies. And many of the cases are from areas of the country west of, not all of them, but many of them are from west of the Mississippi, where they don't have the common law traditions of equity jurisdiction that we had in New England. And so as far as I'm concerned, this is just a situation where the New Jersey Supreme Court analyzed it properly in the Investors Bank versus Torres case, which they decided just last year, and I sent your honors the updated citation. If defendants were to prevail, the loss or destruction by fire or flood of multiple notes relating to bundled mortgages would deprive assignees of their bargained for rights and confer a windfall on each defaulting mortgagor. And I'm talking here not only the earlier opponent, but Hartford too, because they were in on the agreements to be subordinated, and consequently they're trying to get out from under their agreement. There's, in my view, this is a proper case for affirmance. There was plenty of argument. There's plenty of reasons to say that that the Bedford Realty case not only is not implicitly overruled, but is a good decision. Thank you.
First, I have to take issue with the way counsel is framing the test for implicit overrule. Anyway, here it is. In the Wickers case, the way they frame the test is whether the cases are necessarily inconsistent with each other, and where I don't think they said anything about impossibility, and what they said is where party is attempting to distinguish, because any case can make an attempt to distinguish any case from another. They say, and I quote, where any attempt to reconcile the two cases would require the court to establish an arbitrary demarcation, then it is not proper to distinguish, and it is proper to rule that there has been an implicit overrule. So I think that fits this situation to a T. There's can be no question after Shivers and after the Bliss case by this court and Lazard and the other cases that follow Shivers and J.E. Robert, that if you're dealing with a peak problem that's not a loss no problem, or at least a variety of peak problems that aren't loss no problems, that then you have to comply with the UCC. You have to be a peak in order to have standing. So what is the non-arbitrary
Attorney Judge Levine has a question and he's on mute.
So, Mr. Hoops, quick question for you. If you are arguing that a case should be, that we should conclude that it was implicitly overruled, even though it's not explicitly overruled,
right? And
there's a difference of opinion on that. My question to you is, how clear must it be to a court before concluding that a case has been implicitly overruled? In other words, must it be entirely clear, clear beyond a reasonable doubt? How would you characterize the degree of certainty that a court must have before making a decision that something has been implicitly overruled?
Under Wicker, the test is whether, in order to distinguish the two cases, you would have to create a line of demarcation that's arbitrary. So I would say the test is arbitrary. If there's no logical reason to distinguish two cases, even though you can say, well, this case is different in this way, but if that is an arbitrary line of demarcation, if there's no logical reason for, in this case, to kind of carve out that the plaintiff is suggesting, then I think the court should conclude that the earlier decision has been implicitly overruled under the test that's laid out in Wickers.
Well, then if the court concludes that the second case, that there is a logical basis for a distinction, then you're saying that that would be sufficient to conclude that the case has not been implicitly overruled.
I would
Is that
say
a fair statement?
I think that's fair. If it's logical or non-arbitrary, yes.
Thank you.
I also need to take issue with the way counsel reads the two the two key sentences in Shivers. The court says several general principles, I know I read this before, several general principles concerning mortgage foreclosure also guide our analysis. And it goes on to say, standing to enforce a promissory note is established by the provisions of the UCC. I don't know how you read that other than that the court is saying that one of the general principles that concern mortgage foreclosure procedure is that standing to enforce a note is established by the UCC. So with respect to the bankruptcy analogy, the probate analogy, and I would add, if you're going to go down that road, you have to say, you have to put a non-recourse note, like was involved in J. Roberts, into that group of analogies. It isn't. The counsel said that I'm trying to distinguish those situations, and I suppose in a sense I am, but I think that understates my argument. And what I really say is those situations are apples and oranges. They aren't even in the same galaxy as this situation. And again, I come back to J.E. Robert. J.E. Robert involved a non-recourse note. The cleanest example of a situation where you have no in personam remedies as part of the deal from the get-go. And in J.E. Robert, the recitation of the facts state that the plaintiff had an assignment of the mortgage and note. Get a document that says, I, the assignor, hereby assign the mortgage and note. Again, not an endorsement to the note, not delivery of the note, a document assigning it. So if the UCC doesn't matter, why have a whole discussion of whether or not the plaintiff is a Pete? That would have been the easiest case in the world. There's no, if the mortgage and note were assigned contractually, but that's not good enough under the UCC.
Your time is up, but I didn't want to. If you'd like to just conclude, go ahead.
I'll just finish my sentence if I can remember it. That under the UCC, and a note is an instrument. It's a special thing. It's like a check. It's a piece of paper, and if you don't have that piece of paper, unless you were the one that lost it, you don't have anything. And if you don't have anything, you have no. You're not a person entitled to enforce the note. You can't foreclose. Thank you.
All right, thank you very much. Thank you both for your arguments. We'll take this matter under advisement, and we stand adjourned until 9:30 a.m. tomorrow morning.
Thank you.
Thank you.
Thank you.